Let's get started. Once again, many thanks to everybody, and a very good afternoon for those in the eastern part of the middle part of the country, and a good morning to those in Pacific time. Thank you very much for taking the time out of your schedule today. My name is Rathin Sinha. I'm the SVP of Compliance and Diversity Solutions at JobTarget, and I will be your moderator for today's discussion. The online recruitment and compliance industry is evolving rapidly with new technologies like artificial intelligence transforming the landscape. Additionally, regulations are evolving very quickly. This makes continuous learning critical in our field. That's why today's session is not a sales pitch. Instead, it's a learning-focused discussion designed to provide insights. Our topic is both timely and critically important. On January 21 this year, President Trump rescinded Executive Order 11246, which was signed by President Lyndon Johnson in 1965, establishing affirmative action requirements for federal contractors. This action has created a series of questions for federal contractors and a similar number of questions for private industry companies that are not federal contractors. Today, we are privileged to have Matthew Camardella, a principal and co-chair of the OFCCP compliance practice at the leading law firm Jackson Lewis, and one of the authorities in this space, to lead the discussion and present the implications of this action by the new administration, and how both federal contractors and other private industry employers should prepare for compliance in the coming days. Unfortunately, we must say that we have had some technical difficulties right before joining this webinar. And Matt, while he is on the webinar and he would be presenting as planned, his camera is not really working properly. So we decided to move forward, and we would focus on the content and not really have the opportunity to interact over the camera with Matt. With me, Robin Feynman, the General Counsel of JobTarget, is here to assist Matt in the discussions and in the questions and answer sessions. As usually, we all three of us will be available for any follow-up questions you may have after the webinar. Before we move on, this webinar is hosted by JobTarget, a trusted partner for businesses nationwide for more than a quarter of a century, providing state-of-the-art recruitment marketing and technology solutions to streamline and enhance recruiting results, including seamless job posting to state job banks and other job sites, distribution, reporting, support for local outreach activities, and media solutions for federal contractor, OFCCP compliance, and diversity recruiting. Now, before handing over to Matt, I also want to mention that a copy of the presentation and a recording of the webinar will be made available after the event. Now, without further delay, let's get started. Matt.
Thanks, Rathin. I appreciate the introduction. It's great to be with all of you today. And as you heard, unfortunately, the gremlins in my computer are preventing you from seeing me today. So if we think about this, the downside is you're going to have to listen to me for the next 50 minutes or so. But on the bright side, you don't have to watch me presenting to you. So anyways, I hope you find the information helpful. I will do my best to cover what I would anticipate many of your questions to be. And without further ado, here's our agenda. So a little quick background on the Executive Order 11246 itself. We heard some of that from Athene already. Then we're going to talk about President Trump's new executive order from January 21st, what it means. We're going to talk about its impact on federal contractors, and importantly, we're going to give you some tools to recalibrate what you're doing from a compliance standpoint as a contractor in light of the rescission of 11246. But we're also going to talk a little bit, and this will be the last phase of the discussion today, about some of the broader implications for private sector diversity programs as a result of the executive order from the 21st. There's a lot in there. Rescission of Executive Order 11246 is only one small part, even though it has large-scale implications. So we'll reserve some time for the end to talk about DEI programs in a little bit more specificity. All right, so I have to start with, I'm a lawyer, so please don't hold it against me, but of course I have to put a disclaimer in here, which says basically this is not legal advice for you. Specifically, this is for general education purposes. Therefore, if you do have any specific questions or issues that you need to deal with, I strongly encourage you to speak to either in-house counsel or external counsel. Of course, if interested, you can always reach out to me as well. Okay, Executive Order 11246. So you heard Athene talk about how this had been passed by Lyndon Johnson in 1965, and we were set to mark the 50th anniversary of Executive Order 11246 a little bit later this year. In fact, there was quite a number of events that were going to commemorate the issuance of that executive order. Clearly, those have gone out the window. But this landmark executive order, which has undergone a number of revisions since it was originally issued, prohibited government contractors from discriminating on the basis of race and gender. Right? That was its core. Sexual orientation and gender identity were later added during the Obama administration. But this was a civil rights law, right? And it was issued in the midst of the civil rights movement. So in addition to just generally prohibiting discrimination, the executive order went further in that it required contractors to proactively review its employment practices and procedures to ensure equal employment opportunity and non-discrimination, right? So it wasn't just a prohibition against discrimination, it was a directive to undertake quote unquote affirmative action to identify any barriers or obstacles to equal employment opportunity, right? And the tools or the vehicles for doing that type of review were the affirmative action plans themselves. All right, now in addition to the executive order, there were a very long set of implementing regulations, as you all well know, and those regulations contained numerous additional requirements, such as language that you needed to put in job postings, to mandatory outreach you might have to undertake when underutilized for women and minorities, to required workplace posters, et cetera, et cetera, et cetera. And all of those additional technical requirements were designed to help ensure EEO and non-discrimination. And so Executive Order 11246, when coupled with the Vietnam era Veterans Readjustment Assistance Act and Section 503 of the Rehabilitation Act made up three legs to the stool that was government contractor compliance obligations as it relates to EEO and non-discrimination. All right. So obviously with the rescission of Executive Order 11246, one of those three legs is now gone. All right. We also know from our experience that the executive order, along with VEVRA and Section 503, were monitored and enforced by the OFCCP, right? Office of Federal Contract Compliance Programs. That was the agency which, through proactive audits of government contractors, ensured that those businesses complied with those three laws and their implementing regulations. Now, it's important to understand Executive Order 11246 never required contractors to set quotas or implement targets or mandates, right? The regulations actually expressly prohibited contractors from basing employment decisions on protected characteristics. So the executive order AAPs were not what this executive order, this new executive order, declares illegal DEI. Right, so that's important to understand. So that's our context, right? That's our background for the new executive order that was issued on January 21st, and somewhat, I guess, ironically, entitled Ending Illegal Discrimination and Restoring Merit-Based Opportunity. All right. So what did this new executive order do? Well, as we just mentioned, it expressly revoked or rescinded Executive Order 11246. And in doing so, the executive order instructed the OFCCP to immediately cease doing three things, which, if you think about it, align with some of the buzzwords that you would expect to hear given the executive order. So what did the executive order instruct OFCCP to immediately stop doing? Promoting diversity. Stop holding contractors responsible for undertaking affirmative action, and stop allowing or encouraging workplace balancing or workforce balancing. All right. Now, we all know that while the OFCCP certainly held contractors responsible for adhering to the regulatory requirements under Executive Order 11246, VEVRA, and Section 503, the agency didn't require balancing or anything otherwise unlawful, right? As I mentioned before, the whole framework of federal contractor affirmative action was premised on this concept of proactive EEO, evaluating your employment practices and procedures for any artificial barriers or obstacles to equal employment opportunity, and where appropriate, modifying or removing such barriers. Now, in addition to rescinding 11246, the new executive order also directed the Office of Management and Budget to remove all references to diversity, equity, inclusion, or diversity, equity, inclusion, and accessibility principles from contracting and grant-making procedures, and prohibited any federal government mandates to consider any of that in making contracting or grant award decisions, which was a direct repudiation of the Biden administration's consideration of diversity in virtually all federal government activity. All right. So while this new executive order definitely represents a shift in the federal government's attitudes towards DEI programs and diversity more generally, it doesn't change the non-discrimination laws in place at the federal level in this country. All right. Employment decisions based on protected characteristics are unlawful. They were before the executive order, and they are after the executive order. All right. So that hasn't changed. Moreover, employers and government contractors in some circumstances also have additional requirements that are unchanged at this time, right? So for the moment, employers have a responsibility to file EEO-1 reports. That applies to any employer with 100 or more employees. We used to have a smaller slice of employers who also had to file EEO-1 reports, and that was federal government contractors and subcontractors who had between 50 and 99 employees. All right. So if you, as an organization, fall into that small window, you are not required to file an EEO-1 report any longer. All right. For the moment, we still have an obligation to file the VETS 4212 report in the end of September. You also have to continue to comply with any state or local government contractor EEO or affirmative action obligations. So think, for example, state contractors with the state of Minnesota, if certain thresholds are met, are required to actually file an affirmative action plan with the state and submit annual compliance reports. This executive order also doesn't change any state or local government pay or data reporting requirements. So I'm sure many of you have to file the California pay data reporting on an annual basis. Some of you may be subject to Illinois' pay data reporting. And then most recently, we've seen Massachusetts with a filing requirement. And while it's called pay data reporting, it's actually not pay at all. It's just a copy of your EEO-1 report covering Massachusetts-based employees. So no changes at that level as a result of this executive order. All right, so let's talk about how the rescission of Executive Order 11246 and this executive order more broadly impacts what you do day in and day out as a federal contractor. And so the first thing I want to touch on is the executive order makes changes to federal contracts themselves, not immediately. This will take time to manifest itself. But the executive order specifically directed federal contracting agencies to do something new. All right. So those of you who have operated in this space for some time already know that historically government contracts contained an equal opportunity clause, right? Basically prohibiting discrimination and, to the extent applicable, making the contractor subject to the implementing regulations for Executive Order 11246, VEVRA, and the Rehab Act, right? So that's what, when we were, for example, helping companies determine whether or not they had any affirmative action requirements, we always went to the source document. We always went to the contract and we looked for this equal opportunity clause, right? Was there a reference to these obligations? If so, clearly the company had to comply. So with this executive order, though, there's a change, right? That equal opportunity clause, at least as it's been written historically, that's going to come out, right? It may be replaced by one that only focuses on VEVRA and the Rehab Act, but the executive order explicitly instructed the contracting agencies to put in a new clause, right? And that new clause is going to require contractors to do two things. One, it's going to require the contractor to certify or affirm that they will not engage in illegal discrimination, including illegal DEI. And more on that concept of illegal DEI in a moment. But the second thing that this new contract clause will do is require contractors to recognize that that affirmation, right, that certification is a material part of the contract, right? And so while we don't yet know exactly how that language will read, there was a fact sheet that was issued by the White House to accompany this executive order, and it said very clearly that the new contract clause will be, and I quote, an unmistakable affirmation that contractors will not engage in illegal discrimination, including illegal DEI. Okay, let's talk about the language here for a moment, right? So illegal discrimination, as a general rule, we know what that means, right? That would mean violating one of the federal civil rights laws, like Title VII, or the ADA, or the ADEA. But what does illegal DEI mean, right? It's not defined. And so it obviously makes people wonder, but the use of that term, I submit to you all, is not accidental, all right? The administration is trying to conflate the two terms together, right? As a lawyer, I'm paid to parse language, so I'm pretty good at it. So when I look at the term illegal DEI, what I see is the first word is a modifier of the second word, right? So it's illegal DEI. Most people don't read that way. They look at it and say, oh, DEI is illegal, right? So they're going to conflate the two words. And that's intentional, right? That's intended to create confusion. It is intended to create the impression, as you'll see in a moment why that's important, that any DEI programs are illegal, all right? It remains to be seen whether or not that gets defined and how. What I will tell you is we've already seen litigation over this executive order. I'll talk a little bit more about that in a moment. But one of the reasons why it's being challenged is it's constitutionally or under the Constitution, it's too vague, insufficiently detailed. All right, so let's talk a little bit more about the material component of this new contract clause, right? So why does it matter if a term of a government contract is material? Well, it's material because of what is known as the False Claims Act, all right? Now, I certainly was not an expert on the False Claims Act before January 21st, and I'm still not an expert at False Claims Act matters, but now I know enough to understand why this is important, all right? So in order to understand that, right, we need to know what is the False Claims Act. Well, the False Claims Act is a whistleblower statute, all right? It is designed to protect the federal government from fraud and abuse committed by government contractors, right? Think, for example, healthcare service provider submitting an invoice for reimbursement under Medicaid for a service that was never provided, right? That's the type of fraud we're talking about here that was contemplated when the False Claims Act was passed, right? So it's in place and it's structured as a whistleblower statute, meaning it is encouraging or at least providing an avenue for employees to report on their employer's activities, right? So under the FCA, an employee can bring a claim under seal to protect their identity and prevent any retaliation. And the Department of Justice has 60 days to investigate that claim and determine whether or not to intervene in this case and bring suit against the company. They could do it that way, but even if they don't intervene, the employee can still proceed on their own in court. And at the end of that proceeding, if in fact the contractor was found to have violated the False Claims Act, right, and committed some sort of fraud, the damages can be quite substantial. They can be up to treble damages, and those damages are tied to the value of the contract. And more importantly, well, or maybe just as importantly, the employee who originated the claim, they will get between 15 and 30% of any penalties assessed as a result of the claim, right? So a bounty, if you will. All right. So if you think about this for a moment, right, coming back to illegal DEI, so most employees are not going to appreciate the distinction between DEI and illegal DEI, especially individuals who generally don't believe in diversity to begin with. And so now you have all of these quote unquote deputies under this federal law who can report their employers. So if you're one of those people who thinks any diversity is illegal, then you have potential risk as a contractor going forward of an employee reporting you for doing anything diversity related, whether it's legal or not. And sure, you might be able to defend yourself, but that doesn't mean that you won't have to go through the time, the effort, and the expense of defending yourself. Right? So there's only one reason for the administration to take this step, right? Why? They're trying to intimidate and to coerce contractors into abandoning their diversity programs. Right? And if you are an employer who is highly reliant on government contracts, right, why would you want to do anything to jeopardize those contracts or otherwise bring on that substantial risk? All right, so that's the idea behind that provision of the executive order. Now, there is a flip side to this, right? And that is, while the government, the federal government, is trying to strong arm employers into abandoning their DEI programs, if an employer doesn't do enough to ensure equal employment opportunity and maybe walks back some of the things that they're doing and thereby signaling to their employee population that they're not committed to this in the same way anymore, well, that might give rise to traditional discrimination claims, right? Where employees might say, oh, well, you know what? This employer doesn't care anymore about diversity or equal employment opportunity. Maybe the reason I didn't get that promotion is because they discriminated against me, right? So there's a fine line here that government contractors in particular are going to have to walk between protecting themselves from claims, but at the same time ensuring that employees know and appreciate that they in fact are valued and being protected from some sort of discrimination. All right, so let's talk some quick takeaways and some next steps. All right, so as we mentioned, this executive order prohibits contractors from considering protected characteristics in making employment or contracting decisions, right? Can't consider race or gender or any other protected characteristic. Now, that's not news, right? Employers couldn't do that before. So the executive order certainly doesn't break any new ground there. The executive order eliminates any obligations under Executive Order 11246. Right? So no affirmative action plans for women and minorities, no need to comply with that raft of technical compliance obligations under the implementing regulations for 11246. The executive order leaves intact the requirements under VEVRA and Section 503, at least for now. Right? Understand that unlike an executive order, which a president may issue, modify, or rescind at their pleasure, VEVRA and Section 503 emanate from statute, right? They are statutes. So the president can't just change them or rescind them. That requires congressional action, right? So for now, they stand, all right? The executive order does not alleviate contractors of any obligations related to non-discrimination. You still may not discriminate, right? So this is not telling you that you can. And at least for now, once again, the OFCCP remains an agency within the Department of Labor, all right? With, at least for the moment, nominal responsibility for enforcing VEVRA and the Section 503 requirements. I have my doubts as to whether or not OFCCP will survive this administration, but we'll see. My crystal ball certainly doesn't work all that well all the time. And as a reminder, the executive order does not immediately impact your EEO1 reporting requirements, your obligation to comply with state or local EEO affirmative action or reporting obligations, and doesn't affect your VETS 4212 reporting at the moment. All right, so what do you do now if you're a government contractor? Well, you know, and I'm gonna lace some of the conversation in this section with the following theme, and that is understand that what the president did with this executive order is simply remove a compliance obligation that contractors previously had, right? So all it did is remove some requirements of government contractors. The executive order does not tell you what you can do, right? It just tells you what you no longer have to do. All right. So that being said, we certainly recommend that you should discontinue the development and implementation of any affirmative action plans related to women and minorities. You should look to unwind any technical compliance activities related to Executive Order 11246. I'm going to get into some of the details of those in just a moment. And under this executive order, contractors have 90 days, a grace period, if you will, to continue to comply with the Executive Order 11246 requirements. Nothing magical happens, by the way, after that 90-day period, but at least for the moment, they're giving contractors that grace period. All right. As I mentioned before, I think a couple times, you still need to comply with VEVRA and Section 503. So that means, at least for the moment, you still need to prepare affirmative action plan covering veterans and individuals with a disability, and otherwise comply with all the other technical requirements contained in the regulations. And yes, you still need to list with the State Job Service because that obligation exists under the VEVRA regulations. But the Executive Order 11246 aspects of technical compliance, you can unwind. All right. Now, as I just mentioned, just because this executive order rescinds 11246 doesn't mean that you as an employer can't continue to do some of the things that you were doing under your executive order AAPs. The prime example of that are our analyses, right? Trump's executive order does not prohibit you from undertaking analytics and looking at your employment practices and procedures to make sure that, in fact, they are non-discriminatory and offer folks an equal employment opportunity, right? So you can continue to do proactive analytics if you'd like, right? Obviously, you should evaluate the benefits and the, the risks associated with doing those forms of analyses. But if there's a business justification for it, you may want to consider it, right? It can help mitigate risks of discrimination claims or help you in defense of such claims. And they can also continue to further lawful diversity initiatives. All right. In I'm sure, an unintended and ironic twist. The rescission of Executive Order 11246 now frees up contractors to do these types of analyses related to women and minorities in the way that they want, and not in the way that the OFCCP previously mandated. So, you know how you had to prepare plans for each establishment of 50 or more, you had to use these artificial job grouping structures, right? You get to design these analyses any way you want. Now, I highly advise, if you do go down that road, you should do everything you can to cloak those analyses under the attorney-client privilege. That was something that was not available to you as an employer when this was a mandatory obligation under the regulations. You can't actually assert a privilege over government mandated activities. But now, since it's not mandated, you can. All right. Now, if you have an open audit and you have not already heard from the OFCCP that that audit is closed, at least as it relates to 11246, you should feel free to communicate with whoever the compliance officer is that you are working with and make sure you get a notice of closure. If you're involved in active litigation with OFCCP, that should cease, and you know, the wheels of justice move slowly. So you may have to affirmatively make a motion to dismiss the matter if it was based on some allegation under the executive order. All right. So what about the future of the OFCCP? Long and the short of it is, I don't know. I don't know what the future of the OFCCP holds. What we do know is that the OFCCP has been echoing the statements contained in the executive order. The OFCCP was instructed by the Department of Labor to cease and desist all audit activity related to Executive Order 11246 and to freeze any audit activity of compliance with VEVRA and Section 503. And that's why anyone with an active audit should have received a notice last Friday. But other than that, we don't really know. Okay, the OFCCP's status as an agency within the Department of Labor is not statutory. So enforcement responsibility for VEVRA and Section 503 doesn't have to be under OFCCP. It could be folded into another Department of Labor agency. Right? There's also no statutory requirement that the government do proactive audits. So we don't know if those frozen VEVRA and Section 503 audits may actually be resuscitated, or for that matter, if they will do new audits going forward. Still uncertain. Right? We do know that late last week, the OFCCP has a new acting director by the name of Michael Schloss. He was previously in another part of the federal agency and has been moved over to OFCCP. There is some speculation that he is there to help wind down operations at the agency, but we don't know that for sure. All right. So I'm going to give you some practical guidance now, coming back to this concept of unwinding your technical compliance obligations with Executive Order 11246. All right. So have a list of some things that are sort of the most common questions that we have been receiving from clients. The first is that pay transparency non-discrimination provision that previously was required as both a workplace poster and to be included in handbooks. That provision was a byproduct of an amendment to Executive Order 11246. So with the rescission of 11246, that requirement becomes inoperable. All right, so you no longer have a requirement to post and have in your handbook such a provision. That doesn't mean, for example, though, that you can't have a pay transparency non-discrimination policy or practice. You just don't have to have it read exactly like it previously was mandated, and you certainly don't have to necessarily post it. All right. The next one has caused a lot of consternation and a lot of questions, and that is the solicitation of race and gender information from applicants, right? So under federal law, right, with the rescission of Executive Order 11246, this is no longer required, all right? You still may have an obligation to do that under state contracting laws, and you may still want to track that information in order to run proactive EEO analyses on your outreach and recruitment efforts, on your hiring process, et cetera, right? Both to mitigate risk and advance diversity. But you definitely want to consult with counsel on this one. There could be state law prohibitions that apply now that there's no longer a federal mandate in this space. And the mere fact that you're asking may create what you consider intolerable risks, right? So if you are interested in continuing to track that information, please consult with counsel so you can get some specific guidance related to your organization, your state, and any additional obligations that you may have. All right, so the next several, our advice is pretty much exactly the same. And the reason for that is because all three of the affirmative action sets of regulations, 11246, VEVRA, and Section 503, mirrored each other, right, in a lot of respects. And because of that, we were doing the same thing with slightly different language under all three sets of regulations. So take the policy statement, right? We had a policy statement obligation under all three sets of regulations. But now that Executive Order 11246 doesn't exist, depending on how our policy statement reads, we may need to tweak the language so that we're no longer referencing either the executive order or its obligations, but we are still referencing the requirements under VEVRA and Section 503. So you'll want to go into your policy statement and you're going to want to revise it with that in mind. Same when it comes to EO taglines in employment advertisements, right? You're going to want to go in there, remove the stuff that no longer needs to be there, but keep the stuff that does need to be there. The same for your flow down provisions in your purchasing agreements, the same with your vendor notifications, the same with any union notifications if you have unions, all right? And as I mentioned a little bit earlier, if you fall within that slice of the contractor community where you have between 50 and 99 employees, you should stop filing the EEO1 report. All right, so that's our contractor compliance piece of the discussion. Now, with the remaining time, I'm going to switch gears a little bit and I'm going to look at some of the implications for private sector DEI programs just more generally. And look, let's not mince words. This executive order demonstrates and puts on full display this administration's hostility towards DEI programs. Right? And while the federal government is limited in what it can force the private sector to do, it is putting as much leverage as possible into this effort to eradicate what they consider to be illegal DEI. All right, we see this with the rescission of the Executive Order 11246. We see this in the new contract clauses and potential FCA liability I was describing before. But we're also seeing it in the executive order's direction to certain federal agencies that they're to put together lists of areas of concern and egregious practices and lists of egregious practitioners, right? So putting together a hit list of those companies who they think are the most egregious violators of this prohibition against illegal DEI for potential investigation and enforcement activity. All right. There's no reason to do that except to intimidate and coerce the private sector, right? You know, if you're, a small or medium-sized business and you see some mega company get dragged out and made an example of because of their DEI programs, even if any claims are unsubstantiated or unsuccessful through enforcement, the mere fact that they would get dragged through that has to be a coercive effort, right? And you might be looking at that and say, hey, if that's what they can do to them, imagine what they can do to me. All right, so a couple key takeaways. And I apologize if some of this is redundant, but it's important. This executive order does not change the law. All right, what was lawful before this executive order is still lawful. What is unlawful before, or what was unlawful before, is still unlawful. Right? This executive order does not change the fundamental underlying non-discrimination statutes at the federal level. Right? Nevertheless, we fully expect to see an uptick in both governmental enforcement activity and an increase in claims from employees. And those are both traditional discrimination claims and so-called reverse discrimination claims. I mean, really, with the approach the administration is taking, the floodgates are going to open. All right. We can also anticipate more whistleblower claims, especially under the False Claims Act once that new contract provision is put in place. All right. Employers who are reluctant to take any of this risk on and walk back or modify their DEI commitments, you can expect pushback from employees who believe those actions represent a lack of commitment to EEO and non-discrimination. And that can be in the form of just employee relations issues, inability to retain talent or attract talent, but it can also be in the form of actual claims. All right. And we are expecting to see that hit list. So those federal agencies have 120 days to put it together. So we're expecting it. All right. With this slide, what I wanted to do is, given this new climate, this new environment, I wanted to put some of the hot spots up for you so you can kind of get a sense of those types of activities that are certainly going to come under scrutiny. Diverse slate programs is one of them. That's been a very popular tool for a lot of organizations. The most glaring example is the Rooney Rule in the NFL. Any types of aspirational goals or targets are going to be targeted, especially if those goals or targets are tied to compensation or otherwise tied to performance. Any type of program that is exclusive, right? What I mean by that is only women, for example, can participate, like a female accelerator program to help women get into management, or a internship program that is only for Hispanic high school students, right? Anything that only allows a certain demographic to participate is going to be a target, and in all likelihood is probably unlawful. Right? Even things as we think maybe are innocuous, like employee resource or affinity groups, may be the target for claims. So make sure that your ERGs or affinity groups are open to everyone, right? So they aren't exclusive. Right? I could probably have like 10 slides of these types of initiatives, but these are the ones that certainly jump out to me as I think about this. All right. So what steps should you be taking? All right, look, with this current climate and the risks swirling around here, you need to review all of your external and internal communications for anything that makes you an easy target, right? What language are you using on your website about your DEI commitments? What are you saying internally to employees? Right? Review all of your DEI programming for risk, right? Get your arms around what you're doing, how you're doing it, and as I mentioned, how you're communicating about it, right? Once you know where your risk is, you can determine what your risk tolerance is, right? And try to balance that, right? Try to balance what you think your risk tolerance is with the risk that's out there, with the overlay of what are your values and principles, right? Your values and principles will tell you where your risk tolerance is, and then you can calibrate or recalibrate your programming and your communications to come in line with that risk tolerance, all right? Don't forget, your employee population is diverse. Some will be sympathetic to what the administration is attempting to do here. Others will not, right? They will feel under siege. They will feel under attack. So we're encouraging employers to try to find a balance in communicating the company's intent to follow the law while still reassuring employees that the company is committed to ensuring EEO for all and that it values everyone. All right. And lastly, don't forget how folks are feeling right now. All right. In a highly politicized environment, people are taking sides, and a lot of people don't necessarily feel safe. They don't necessarily feel supported. So it's important that folks feel safe to come to work every day, right? And the messaging that you send can help people feel that way, all right? Without having anything to do with diversity, right? So that's an important takeaway, but really getting your arms around and assessing what your risk is associated with all these programs is something that we highly recommend. Get your in-house counsel involved. If they're not situated to do it, get your out-house or external counsel to help you with that. You know, obviously, I'm always here to help should you have any specific questions. So with that, I think we have a few minutes left. If there are any questions that my organizers would like to throw my way, and I'll do my best to answer them. But otherwise, I appreciate everything.
Yes, thank you so much, Matt. That was a great presentation. We appreciate it. We also have some great questions that came in, so we could take the next few minutes to try to cover some of them. So the first question that I was hoping you could address is, with this executive order change, how are OFCCP audits expected to change for the seesaw lists that have already been published? Additionally, how does this impact the record keeping requirements for current and 2 prior year AAPs?
Good questions. All right. So the first question, I don't know how to answer. We have a CSAL. The OFCCP was working on it before the change in administration. We've had no word as to what they're going to do with it going forward. We do know that there is a full stop on initiating any new compliance reviews at the moment. So I think the future of the OFCCP will determine the future of any CSAL. So we're just going to have to watch. In terms of, Ron, what was the second question there?
So the second part of that question, let me scroll back up.
Oh, record keeping. Got it. Yeah.
Yeah.
So under the VEVRA and the Rehab Act regulations, there's a 3-year record keeping requirement around stuff for your outreach and recruitment and your assessment of your outreach and recruitment efforts. So both the data and your assessment. So all of that needs to be maintained for at least 3 years. So I think the safest bet is keep 3 years worth of AAPs and their underlying data handy.
Okay, great. So we had some other questions about self-identification. Will we need to remove all self-identification questions from our applications and new hire documentation? Similar question that came in. Do we still ask for voluntary race and gender identification for EEO1? How else would we know? Is it just for applicants that we stop?
Yeah. So for applicants, you must still solicit veteran and disability information. So that is still in place. Whether you continue to choose to solicit race and gender information from applicants, as I had mentioned a little bit earlier, is really going to be an individualized decision based on some state law implications and frankly, what benefit you're going to derive from it versus any risk that you're assuming. For employees, you still need to solicit race, gender, veteran, and disability information. That is unchanged at this time, so you would continue to solicit that stuff.
Okay, great. Thanks for clarifying that. We have another question. Are programs designed to help employ people in underserved communities considered an illegal DEI program? For example, if we recruit in high schools in lower income areas and provide scholarships for students with employment opportunities after training?
Yeah, good question. So economic status is not a protected characteristic, right? Race is. So you can indirectly, right, sort of impact your diversity initiatives by focusing on those types of underserved or economically challenged communities. But because it's not explicitly tied to race, I think it's relatively safe, right? I'd have to see the details of the program, like who exactly is eligible and that sort of thing. But assuming that it's not exclusionary to the benefit of one group versus another, but open to everyone, then again, it's probably safe.
Okay, great. So it looks like we are about up to time. There are some more great questions that have been asked, and we're happy to follow up with those who have pending questions, or please reach out to Matt or any of us at JobTarget. We thank you for your time today, to Matt, our presenter, and to all of our attendees.